Two. We'll now move on to Senate Bill 108. Senator Washington, welcome back.
Good afternoon, Mr. Chairman, members of the committee. Great to be here. Great to be back in this, my favorite committee I've ever been on. You know, it's my favorite committee, man. It's not a lie, it's the truth, brother. It's the truth. For the record, Senator Alonzo Washington here to speak on Senate Bill 108. This bill is a really great bill. It requires the governing body of a common ownership community to develop a smoking policy that is at least as stringent as the applicable state and local laws regarding smoking for multifamily dwellings, and that's limited to condos only. Condos only. I know the folks who are in the opposition to this bill are going to come up and say, well, what if you lived there for such a long time and they create this policy and whatever have you? Let me make some things clear. This doesn't require them to say that there's no smoking there. This doesn't require them to say there is smoking. That just says that this bill only says that they need to just create a policy on smoking in condo units. Just imagine you owning a home, a condo, you've been there for 20 years, someone comes in there and buys the unit next to you, and that person next to you ends up smoking. And they smoke profusely. They smoke every single day. They smoke every day, and it comes into your home. That could be a nuisance to that person. But there's no law or rules or regulations for relief for that homeowner, for that person that lives there. We're letting that homeowner down by not passing this law, requiring them to create a policy so that there is relief for that homeowner. We're talking about just homeowners, people who purchased their home and been there for years and just want to make sure they can raise their family in those homes. Imagine you're a homeowner, you're a condo homeowner. You just came home with a new baby and you have 3 other little babies with you. But the next door neighbor just purchased their home and they end up smoking there. The smoke gets into the home, then it causes problems with the babies and everyone else that's in that unit. I'm asking this committee to take this bill seriously this year, because I think that this is going to be continuing to be a long-standing issue. The AG supports this bill. The Attorney General supports this bill. They're here to speak on behalf of the bill and legislation because they have no recourse to help in this types of situation. So they're asking for this to solve some of these issues. I know they have examples for that too. I know you guys have heard this bill multiple times since I've been in the Senate, and even a year before I wasn't in the Senate. But if you pass it this year, I promise I won't come back again with this bill. On this bill only. This bill only. And how did Nick Charles get all the way up there, man? That's crazy. No, I'm joking. But with that said, I urge a favorable report on this piece of legislation, and I'll take any questions.
All right, thank you very much, Senator. Questions from the committee? Senator McKay.
Senator, thank you for this bill. Not necessarily agree with it, but your observations are spot on. Thank you.
All right, excellent. Further questions from the committee? All right, I think we have one. You have a witness here is from the Attorney General's office. Yep. She can come on up. Karen, good to see you. Welcome.
Mr. Chair, Mr. Vice Chair, members of the committee, my name is Karen Strawn, and I'm with the Consumer Protection Division of the Office of the Attorney General, and we are here in support of this bill. As the good senator said, we do receive complaints from time to time about individuals who are living in a condominium unit and the condominium next to them is smoking and it's carrying over into their unit, and they want to do something to try and protect themselves. And they file a complaint with our office and we mediate, but there's really nothing without some sort of policy, there's really nothing that an association can do to stop that individual. They're in their own house, they're doing what they need to do. So really what this does is it just says make a policy. You can make the policy whatever you want it to be. The policy can say you can smoke on common grounds. The policy can say you can smoke in your unit. The policy can say all kinds of things, but it's to protect against situations where when you're getting ready to move in, so that you as an individual know what you're moving into, and you can make a decision based on what makes sense for you. Smoking is deadly. I think we can all agree on that. And as a result, I think it's important that we ask these associations to make some sort of policy so that people know what they're dealing with when they're purchasing a home. And for those reasons, we ask for a favorable report on this bill.
Thank you, Mr. Chairman. So if this passes, what are you going to do with it?
Well,
So I have lived there 20 years. Somebody moves in. The group then decides we want no smoking. I've been there for 20 years. What are you, the consumer protection, going to protect my rights? Because I've been there for 20 years and now the group has decided they don't want to do any. Are you guys going to buy the property?
of course not.
Oh, okay, but you have created a legal, if we pass this, we're now creating another legal wranglement and allowing the AG to be in favor of this. The other question I would have is, I am 100% against smoking marijuana. Recreational, medical, whatever. We went through the process, we've decided that this is what we're gonna do. Is there a difference?
Is there, what do you mean by is there a difference?
in the smoking of marijuana, and then if there isn't, and I have a medical card, now aren't we gonna be getting into determining if somebody actually has a medical reason for it? And I think you're opening up Pandora's box, and I don't know how we make it pretty. And
Well, these are all considerations that the association gets to make when you're making a determination of what the policy is going to be. And that would require them to meet with the association members and make a determination as to what the group wants. It's, you know, that's one thing that is a little unfortunate about living in a condominium unit, is that sometimes you have to make decisions that are what the group wants and not necessarily what each individual wants.
so I'm being there for 20 years. The group comes in and decides that they don't want to smoke, we have to have a policy, and they decide no smoking. What am I supposed to do with being there for 20 years?
Well, in most cases, the policy is going to consider, first of all, what each person wants. But let's say that you are the one and only person in the unit, one and only person in the association that wants to have smoking allowed. I would think that the association would do some considerations, like making sure there are places of common element areas where you could still smoke, so that you could still be able to do the things that you wanted to do.
Are those protections in this bill?
The bill simply says make a policy. It doesn't say it has to say anything in particular other than being at least as stringent as what the state and local laws are.
So there again, why is the AG weighing in on this? Other than I know that we believe that smoking is bad, except if it's marijuana, it's okay.
Because it's something that there are a lot of people that are having problems because they might live in, just as you're saying you have an individual who lives there for 20 years and smokes, you might have an individual that lives there for 20 years and doesn't smoke. And that person should have just as much rights as this person who smokes to be able to decide whether they're in a position to be in a place that allows them to keep up what they're hoping to be their environment.
Okay, I go back and it'll be my last. I've lived there for 20 years. What am I supposed to do? Get voted out?
Well, you don't get voted out, but if you
Create a no smoking policy, and I've been doing it for 20 years, now I'm violating the policy. Now what is now that we're giving a legal opportunity for the association to what? Do fines, we're opening up Pandora's box, but thank you.
Thank you.
Yeah, if I could just respond to that, Mr. Chairman. this bill simply says, as the Assistant Attorney General said, it sets a policy. It does not say that they have to be penalties. The penalties can be zero. It doesn't require them to say that they can't smoke or will smoke or they all can smoke. It doesn't say anything like that. The association decides amongst themselves, just like they can decide that they're going to increase the condo association fee by $250 every month because they need to pay for such and such X, Y, and Z without either with your vote or without your vote. They can do that. Whether you've been there for 20 years or you've been there for a month, they can vote for those things. Now, I wouldn't support that motion in my condo association for $250 increase, but I support this measure because it's simple. It says create a policy so that you all agree to, and the majority of the community there, according to your bylaws, agree to, and you all have to adhere to this. And because it's a common ownership community, they set their own bylaws and ways that rules can be enacted within their association. And so I think this is a simple common sense law and something that this committee should pass.
Thank you, Mr. Chairman. And yes, I remember this bill, Senator Washington. And I can see both sides of this, but I have to drill it down on the, questioning this. So kind of dovetailing to Senator McKay, it is, to me, problematic to retroactively create policies. So there was sort of what the lawyers would call detrimental reliance. You buy a property, you're allowed to do these things. You're a smoker, and let's say. You could also be disabled and have great difficulty going outside. You could also be a young woman who feels extraordinarily unsafe in whatever common areas you might have. So you could potentially put quite a burden on the smoking population. So it's going to be a tough balance. But I'm sort of wondering why there aren't, I appreciate Senator Washington saying, hey, there's no real guardrails in the bill, but that also means there's no limits, which means you could in many ways be quite unreasonable with the smoking population, be it marijuana or cigarettes. And if somebody has a medical reason for smoking marijuana, and now we're treating them differently than someone who has glaucoma or just some other disability that makes it very difficult for them to go outside. Can you kind of address some of those balancing factors and the fact that there are no guardrails or limits in this bill to reasonableness for all people involved?
Well, while in your opinion, there's no guardrails to reasonableness, at the same time, you have people who want to be in a situation where there's no smoking. So what the association needs to do is to weigh the rights and the obligations to the people of the community and to do what the majority wants. That's how condominiums associations work in general, that you're doing what the majority wants. So there are constantly new rules and regulations being made to affect people regardless of how long they've been living there. There are ways to grandfather people in, and they can consider that and consider grandfathering a person in to make sure that they are protected because they've been there a long time. There are lots of ways to do it. It's just going what the majority of the people want.
Well, I guess what I'm struggling with is, for example, how would I phrase this? Give me just a moment. You've got people that bought into the property knowing you could smoke at the time, and you've got other people that are buying into the property knowing smoking is allowed. So I feel like there is some weight to all the people already there not to make anything retroactive. I get sort of prospectively new condominiums coming in and saying, hey, we're going to be a no smoking condominium. That's what, or a common area, whatever the rules are going to be. So there's an inherent unfairness, in my opinion, when you are going inside an individual's private residence. But I do understand, the difference between a home and a condominium, but I'm just struggling with that. The other issue I have is I can also appreciate if someone is smoking a lot, marijuana, tobacco, whatever, and it is getting into the ventilation, if it is, then you get into nuisance laws and things like that, where you already have laws, and processes for remedy. What I'm struggling with again is assuming someone lives in a condominium and takes all the extraordinary efforts to keep the smoke inside their condominium, but another neighbor just simply wants you just not to smoke because there are some very self-righteous non-smokers. Again, how does this bill protect this balance?
Well, I think the bill protects the balance by the mere fact that you can make the policy whatever you want it to be. I think it protects that balance because...
Whatever you want it to be isn't a balance, though.
But it is a balance in that the association, when they're making that determination, can make a determination that says you can smoke anywhere. So that could be the determination that they make. Or they could make a determination that says only new people moving in are the ones that are going to be prevented from smoking. So there is a balance in that the association is actually making the balance itself by making a determination as to what.
So let's say an association, last question, is unreasonable. And by unreasonable, I mean they're like, I don't care if you're sick, I don't care if you're disabled, I don't care if you have a medical card, and I don't care if there's just one of you and you've done all this stuff. What recourse, and there may be none, but because I'm not a condominium lawyer, what recourse does the individual, the minority, because might doesn't make right, right makes right. So I get that condominiums are ruled by majorities, but right is right. So if somebody's just drilling down and the whole group is being terribly unreasonable, is there any recourse in this bill for some review? I guess the answer is probably no, but I'm just curious because I'm not a condominium lawyer.
Do you mean review of the policy that was made?
Yes, especially, if I load it up with lots of unreasonableness that even you all might agree is pretty unreasonable.
Lawsuit, right?
Huh?
There could be a potential lawsuit there, right?
I don't know. I'm not an expert in condominium law. I don't know if there's a reasonableness in condominium umbrella law, legal concepts, if there's an inherent reasonableness that has to occur, or if might makes right in a condominium and anything the majority wants, not just this, but anything, they can do it. So I don't know how that works. So anybody that could address that.
Well, basically, if you were to make this policy, this would fall under your rules and regulations. And the law already has a plan in place for people who disagree with a new rule that was put in place. And it allows them to go to the board and ask for an exception, number one. If they don't grant the exception, it also allows, if the majority of the association feels differently, it allows a process by which you go through and you can overturn the rule that was passed. So there are policies to do that. Again, it would be a situation.
But not an individual's ability. You'd have to be a majority. Again, it might make right a majority.
The individual can do an individual looking for an exception. It would be the majority that would be doing the changing of the rules and regulations.
Thank you, Mr. Chairman.
And can I just say something real quick? The Senator mentioned the nuisance laws. I have not found a place where it has worked in this situation for being a nuisance. If the smoke seeps into your home and you try to file a grievance, and there's really no recourse or relief for the homeowner for any situation. Like, that's what we're trying to resolve here. Like, you can go to your condo association right now and say, this neighbor has been smoking and it's interrupting the way I live in this home, and how can you help me? They will say there's nothing. They have said, condo associations across the board, across the state, have said that there's nothing that they can do when it regards to smoking.
Well, nuisance laws exist, so I think you're getting misinformation there, and that is also kind of makes the point that condominium associations aren't all that with it if they're telling you there's no remedy for a nuisance. So I'm troubled by that, but that also speaks to this bill and the fact that apparently condominium associations really don't understand what goes on and how the law works. So it's not a good point. Yeah, thanks.
Senator West.
Thank you, Mr. Chair.
I love this bill.
I'm flummoxed by this bill. Right now, these governing bodies of common ownership communities have the right to adopt whatever policies they want. If they want to adopt a policy relating to loud music, they can do it. If they want to adopt a policy relating to unusual pets, they can do that. Unusual smells, they can do that. To the extent they haven't done it, it's because they don't want to do it. So what this bill does is say you must adopt a policy on smoking, and it must be as stringent as the local and state laws. So if they don't want to do it, they'll just say our policy is to adopt the local and state laws, which basically is a non-policy because they already apply. So I'm not sure what this really gets at. If I were on the board, I would say stay as far away from this as you can. You're going to buy yourself nothing but hassles. We've heard some of those hassles rehearsed just here with the interplay between Senator, yes, sorry. And we don't want these kind of hassles, so let's just stay away from it, and we'll say our policy will be the state and local laws, period. That's what I would do. So why are we going to force condominium owners, associations, to adopt a piece of paper which says we apply the state and local laws? It seems like a hassle and unnecessary.
Well,
Go ahead.
it's really allowing people who don't smoke or who don't vape or do marijuana or anything like that a voice in this matter as well. Because they, as the association and the members of the association, are the ones who are going to be voting to make a determination as to what's going to be done. So it's allowing a voice for everyone.
So what you're going to do is generate an acrimonious meeting of the governing body of each of these organizations to go through all the pros and cons of adopting all kinds of elaborate policies. And in most cases, if they're sensible, they will say, we choose to adopt the policy we have right now, which is no policy on this issue other than whatever the state and local laws is.
Then that's a policy. The policy has been adopted.
Why
Box checked, move on to the next condo
association. Why should the Maryland
association.
General Assembly force them to go through that exercise?
Because we just legalized marijuana here in the state of Maryland. And we regulated it, and it's legal now, and it has been bothersome to many condo homeowners in this state. And so having an ability for them to have some type of rule within their bylaws that says that either they can or cannot smoke, that goes through that rectifies that argument or that contention between two neighbors, is helpful. If they say smoking is allowed, then smoking is allowed, and then that's the end of it. That's the bottom line. If smoking isn't allowed, then that's another method to resolve that issue. Right now, there's no between neighbor to neighbor disputes within condo associations with regard to smoking. There's nothing in the laws or nothing in the bylaws that prevents that person from encroaching on their quality of life. That who own that property for over 20 years, who's been there, paid their taxes. The state of Maryland is not helping them. State of Maryland is not helping them. We have not. We're leaving. They need help in this situation, and we come here to Annapolis to resolve issues that happen in our communities. This is a significant issue that's happening in my community, where I know these condominium owners really want to make sure they can rectify the situation between neighbor to neighbor.
Okay, thanks.
Actually, I'm really glad my colleague from Baltimore County raised that question, because that's where I was going, but I have a different take on it. And that is that right now, condo associations could make this policy, correct? They could sit down and have these hard discussions, which they already do for so many other things, correct?
Correct.
Okay, so we're not imposing any new, how do I want to phrase this? We're not saying you must outlaw. We're not saying, if we were to pass this, we're not saying you must allow. We're just saying that you already have this authority to do it, and you must do it. Am I reading this bill correctly?
That is correct.
Okay. So my different take from my colleague is that I have condominium associations in my district that desperately want this policy. And there are others who don't want to have this hard conversation because it is hard. And so I think we are actually giving them the support that they need to move forward and have these conversations, as condo associations do on so many other things. I mean, I was just having a conversation with somebody about noise ordinances. I know people who, the harder they concentrate, the louder their music is. I need absolute quiet. Condo associations make those decisions all the time. So my question is, now that I'm in the Senate and I can make these statements, which we never used to do in the House, my question is there anything in this bill that would dictate one way or the other that says you have to allow it, you have to have penalties, or is it just saying, you already have this right, now go ahead and exercise it?
That's correct. It says that you have the right to do this. You can do it, have that tough conversation, and move forward with it. You do not have to have any penalties associated with it. You decide where you go. And in this committee, we're assuming the worst, and that folks will outlaw this, but we're giving them the ability to make the decision on their own.
Thank you.
Senator Love, you're correct. In the Senate, we treat people like adults, so that's good.
Terrible.
Further questions from the committee? All right. Thank you both very much. Thank you, Senator.
Thank you.
All right, so that'll conclude the testimony for the proponents of the bill. We now have one witness in opposition of the bill, Mr. Boriano. Welcome.
Good afternoon, Mr. Chairman, members of the committee. For the record, Bruce Beriano, here on behalf of the tobacco wholesalers. Very strong opposition to this bill. I'll try and speak as quickly as possible. I'm sorry I have so much limited time, but I'm very disturbed by this hearing. I really am. First of all, I'm in 2 condo associations, so I'm very familiar with them as a condo owner, both in Crisfield and somewhere else. When you go into a condo, when you buy one, I think it's your obligation to read the condo rules. Know what you're getting into. You are going into a combined living arrangement with people that you don't know. That's what condos are all about. You're not in your own apartment, in a rental apartment, and you're not in a private home, and there are responsibilities there. Secondly, I'm very disturbed, very respectfully, that this bill is not being read properly and accurately to the committee. Senator Love, it's a pleasure to see you. The answer you was given, very, very respectfully, is inaccurate. It's not correct. If you read the bill, and I'm gonna take my time and read the bill for you. The bill applies to smoking, vaping, and marijuana, very clearly. The definition of smoking includes that. Secondly, if you go on page 2 of the bill, it requires, there's the word shall. If you go to page 2, line 22, the governing body of the condo association shall develop a smoking policy that is at least stringent as the applicable state and local laws regarding smoking of property in that area. So it's mandatory. It's not permissive. It doesn't empower. It mandates that they must have a smoking policy. And it further states in this bill that under this mandated smoking policy, the locations of where in the condo it's authorized for you to smoke, and the locations of where you cannot smoke in the condo, mandatory. And then if you go to page 3 of the bill, and excuse me for just reading the bill, but if I may just have another moment, Mr. Chairman, if you go to page 3 of the bill, it mandates, it shall mandate that there be a process of filing a complaint against an individual who violates this policy, and it also mandates, the word shall is used on page 2, and it applies here to paragraphs 4 and 5 on lines 3 and 5. On 5, it mandates that there shall be penalties and fines. Mandates it. What are penalties? Is it jail? Is it, I don't know what penalties means. Fines is money. And then the further kicker of this bill on page 3, lines 7 through 13, is that nothing in the bill limits or preempts local government and municipalities from doing something more stringent. So it empowers local and state government to be more stringent than that. Very respectfully, this bill is fraught with problems, and it was killed 7 years in a row in the House and in the Senate, and it's the same bill, and I would urge an unfavorable report.
Senator Love, then Senator McKay.
Thank you.
Thank you, Mr. Chair. As long as we're reading the bill, let's read it correctly.
Yes.
Mr. Beriano?
Yes.
Page 3, line 5. Any penalties or fines for violating the policy. It does not say you must institute penalties or fines. It just says any, if there are any. It doesn't say there must be them.
May I
Please.
all right, please kindly, and I'm very respectful. No, I mean it. Page 2 of the bill, please. Line 26. A policy under subsection C shall state, shall state the locations of where you can and where you can't.
And
it
any
shall,
penalties, which means there could be no penalties. and any penalties. Does not say, and there must be, and there shall be penalties. It does not say, and penalties. It says, and any penalties, which any can include none in statutory construction.
Very respectfully,
With all due
I don't
respect.
agree, because on line 4 and page 3, you have the word "and," so it's not disjunctive. So the point is, and I'm just reading the bill, the point is, if you're on D, 1, 2, 3, 4, and 5 have to be done. So with the "and," not the disjunctive, which is "or," which we all know, that means that there has to be adopted in the policy, penalties and fines for violating that policy, and that is mandatory. Respectfully, that's the way I read it, but you are the legislator and I am not.
Thank you, Mr. Chairman. As one of the very few non-attorneys on this committee, can you answer if we pass this bill, and I've been living in this condo association for 20 years, and they determine that we're going to have a no smoking policy, what am I supposed to do? Do I have to sell my place? Does the Attorney General weigh in? In any way, does this not open up some form of Pandora's box that I don't know why the AG would want to weigh in on?
You have, respectfully, you have a major problem. You really do. Because, again, assuming condo owners, when they buy a condominium unit, they read the governing documents which are applicable at that time that they buy it. They also participate, over the years of the condo meetings and all that kind of stuff. If they automatically, and the way I read this bill, if this bill were to pass, the condo association must adopt a policy, okay? Theoretically, yes, it could be a policy of doing nothing. I don't, personally, in my life experiences and my condominium meetings that I've gone to ad nauseum, and I was president of a condo association for 4 years at one time, I don't think if this is passed, it's going to create a lot of conflicts and a lot of problems in the condo associations. They're not going to ignore this. People are going to interpret this that the legislature says you've got to have a no smoking policy. Not only that, but everything else. So, but you have a problem. You either have to move out, sell your unit, or just be miserable. I'm not trying to make a joke. Be miserable. It's the obligation of someone coming into an association to see what are the rules in advance, because they're going to be living in a joint environment. They really are. So there really are those personal obligations. And it was pointed out, condo associations can do this, all of this right now if they want. They don't need this. But what this bill does is force them to do something, to force them. And again, it's not just smoking. It's those that have the ability under the law to do medical marijuana or to vape. And it tells where you can do it on the premises and where you can't do it on the premises. This bill creates enormous problems, and I think that's why, both in the House previously and in this committee previously, the bill has not been favorably considered, because not only because condominium associations can do this authority, they can act now, they don't need this, but secondly, the way this is drafted, it's so rigid, it's going to create a lot of problems.
Thank you.
A lot. It's going to be.
Thank you, Mr. Chairman.
Thank you very much. Appreciate the opportunity.
The testimony in the hearing for Senate Bill 108. We'll now move on to Senate Bill 150.